So, the Brackenes are a white couple living in Texas, and based on public statements they've made and blog posts the wife made, for religious reasons, they feel it's very important that they adopt Indian children, and they've elected to do so. However, the Indian Child Welfare Act does allow for tribes to intervene and to have a say in what happens to their children. And so when that process started, the Brackenes were very upset. This lawsuit was filed by Gibson Dunn less than a year after the movement at Standing Rock. So those two things are not a coincidence. If you can take a nation's children, you'll eradicate that nation, because without any children, you literally do not have a nation anymore. And the folks who are fighting ICWA understand that. Again, these are well-funded attorneys from oil and gas who don't want to be told by a tribal nation, no, you can't build that pipeline through our burial ground. I mean, the youth at Standing Rock, the tribal leaders showed up, but at first it was the youth. It was kids, children. It was children who are protected by ICWA who stood up and said no to that pipeline because they had relatives who were buried in the path of that pipeline. And the pipeline didn't like that, right? But if you can eliminate those nations, if those nations no longer exist, then I think oil and gas understands there's a lot more profit to be had.